Hi, do you have a few moments to talk?
This is Susie from Fast Talk Insurance Company. I'm investigating your accident. I'd like to come out and talk to you.
Should you talk to a claims adjuster after an accident?
My honest answer? No. When a negligent driver injures you in a car crash, you already have enough to worry about.
I hope you have a lot of liability insurance.
Stop talking!
You must ask yourself a few questions. Should I talk to the insurance claims adjuster if they call? If I speak to the adjuster, should I trust them? Will they give me the compensation I deserve? Will they treat me fairly? Let's see, the answer is no, no, and no. Hi, I'm Carol, the nice old claim lady. Over my lengthy insurance career, I specialized in investigation, liability, injuries, coverage, and litigation. If I'd handled your injury claim back then, I would have treated you with kindness and empathy. Still, I would have done whatever it took to control you so you wouldn't decide that you needed an attorney. Those basic principles never changed. Now that I'm older and wiser, and I no longer work for insurance companies, I have no problem telling you how I really feel. Number one, never trust a liability adjuster, no matter how nice they are. Number two, consult with a car accident attorney before you make a mistake you can't undo.
What about talking to my own insurance company?
You can't avoid your own insurer. Your policy is a contract of utmost good faith, blah, blah, blah. You have to cooperate with your insurer, but you don't have to talk to the liability claims adjuster until you're ready. In fact, you don't have to talk to them at all. Of course you want the other guy's insurer to pay your claim, but even if you give them everything they ask for, they might not pay you anyway. Pay attention to your instincts. When you're dealing with any claims investigator, trust is always an issue.
I'm sorry, sir, but we can't pay your claim. Our investigation determined that you were at fault.
When a liability adjuster contacts you, they are working on behalf of the person who hurt you. They do whatever it takes to complete their investigation quickly, reserve the claim, deny the claim, or close their file. An adjuster needs your version of the accident to make a decision. Just because they listen to your story, ask for your medical records, and offer heartfelt sympathy, that doesn't mean they plan to pay your claim. You can cooperate with an adjuster, but you still have no control over anything they decide to do.
I'd like to ask you a few questions. May I record our conversation?
Yes, that's fine.
Should I give the adjuster a recorded statement?
That's a definite no. There's a reason for that. Your recorded statement can provide so much evidence. That's why it's an adjuster's #1 priority. For claims investigators, statements are a priority because they provide critical accident information. When I investigated injury claims, I was a member of a team on call 24/7. Any one of us might receive a phone call in the middle of the night. When we answered those late night calls, we had to wake up and start thinking like a claim investigator. Within minutes, we would write down the details. Insured's name, claimant's name, accident location, injuries. Those middle of the night calls usually meant a bad accident with serious injuries. That meant we had to start working on our investigation immediately. We would call the insured to record their statement, yes, in the middle of the night. That was the point of the on-call system. Contact injured people immediately. Get the details. Take control of the situation. I would contact the other driver, briefly discuss the accident, and schedule an appointment for the next day. If they were in the hospital, I would visit them in their room, sometimes bringing flowers or a get well card. If they were recovering at home, I would drive the distance and knock on their door at exactly the right time. I would talk to the injured person and take their statement, with their permission, of course. Usually they were glad to hear from the other insurance company, so they cooperated fully. During my initial visit, I obtained their permission to conduct an interview, then asked if I could record it. I never called it a recorded statement, as that sounded too much like legalese. I discussed their injuries and observed them as they moved through their home. I answered questions about my investigative process while considering what type of witness they would make on their own behalf. I was one of the good guys, but I still had a job to do. When I interviewed an injured person, I would ask questions and listen for answers that might trigger liability issues I hadn't previously considered. The injured person might say some seemingly insignificant thing that might inspire a deeper question. People said some really stupid things sometimes, things that shifted the narrative about who did what and who was at fault. They said things that caused me to reduce their settlement due to their own comparative negligence. They spoke before thinking, often explaining their version in a way that forced me to deny liability and refuse to pay their claim.
You can't take back what you say.
As the weeks and months pass, you might not remember an adjuster's questions or your responses, but you still can't take back what you said. They will have a permanent record. They can store your recording digitally or have it transcribed to a digital or paper document. They can store it in a closed file or pass it on to a defense attorney if you decide to file a lawsuit. When you allow a liability insurance adjuster to record your statement, you can never take back what you said.
So, if I talk to an adjuster, I risk everything?
I'm trying to be honest, so yes. When a claims adjuster begins an investigation, they're often biased by their policyholder's version of the accident. Even if an insured reports that they're not at fault if you're injured, the adjuster still needs to conduct a full investigation. That includes talking to you and asking questions with significance you might not understand. In fact, they structure questions in a way that reveals evidence that might support their insured's version. They won't explain that to you until after they get the information they want, or maybe not at all.
What questions does an adjuster ask during a statement?
I began each interview with identity questions, name, address, etc. Then I moved on to questions that helped me assess liability issues. I understood that most people wouldn't recognize the purpose of my simple questions. They would often respond in ways that jeopardized their right to recover damages for their injuries. To figure out if you were driving distracted, they might ask, were you using your phone or a hands-free device? Did you have any passengers? Where were they seated? What were they doing just before the crash? When did you first see our insured's car? When they want to confirm your injuries or recovery status, they might ask casually, how are you? If you say, I'm fine, the adjuster may conclude that your injuries were inconsequential. If you don't understand the legal issues, you might describe negligent actions you don't recognize as negligent. When the adjuster replays or transcribes your recorded statement, they might identify self-sabotaging descriptions they didn't notice while they were interviewing you. If an adjuster asks to take your statement, no is always the wise response.
So, the claim person will use my own words against me?
Of course they will. Depending on what you say, the liability adjuster may rely on your own words to make claim decisions that affect you negatively. Of course, they need more than your statement. To assess liability for an accident, the adjuster must obtain the police report, conduct a site investigation, and obtain statements from their driver and any witnesses. They must document any other evidence they consider relevant. And of course, they must talk to you. Your statement can be the deciding factor in a liability insurer's decision to pay, compromise, or deny your claim. If you file a lawsuit against the other driver, a defense attorney will refer to your statement and the adjuster's investigation to defend the case. As the defense attorney prepares to depose you, mediate, or try your case in court, they will review your statement to figure out how to question you. You will probably have forgotten a lot of the facts by then, but they will have a digital recording and a transcript of everything you said during your recorded statement. Talk to an attorney before you talk to any insurance adjuster. Some people prefer to handle their claims without legal assistance. Others just don't want some attorney taking a cut of their potential future settlement. But remember this, when someone hurts you in a car crash, you have one chance to get it right. You need all the help you can get. I'm not an attorney, so I can't give you legal advice. But I spent years investigating, evaluating, and negotiating injury settlements and supervising an insurance litigation unit. I've also spent a lot of time writing content for attorney websites. I learned a lot about their initial process. You can call or email an injury law firm and schedule a consultation to discuss your case. The first time you meet with an injury attorney, it's usually an information sharing session. You don't have to commit to taking immediate action. And the consultation is usually free. When you and your attorney agree to work together, you can go home and take it easy. Your attorney can deal with a liability insurance company, and you can rest, relax, and heal.